It's so nice to see you again and so nice to hear you again. Maybe I'll read you again in the chat. My name is Kateryna. I am working in Legal IT Group as a head of privacy practice. And I would be terrified to know you too, because I want to know where do you work and what interests you to in privacy, what drives you to pursue the privacy career, or maybe you are thinking of switching to the privacy career. So anyways, write in the chat where you work, where you live, and what are your plans? What drives you to listen to me today? So okay, I'm waiting for you in the chat. While we start, I will start with the simple things. My name is Kateryna Dubas again. I'm working as a head of privacy and data compliance team here in Legal IT Group. I have a CPA certification too, so I am working as a DPO for a few firms that are working outside Europe and outside the borders of Europe too. And we are situated in Ukraine and Kiev, and everything looks fine so far, I guess, but still we are working on getting the situation very, very better too. So, wish us all the luck. Okay. While we are all gathering here, and while you are understanding who is this weird girl talking to you right now, again, I'm a DPO working for a few companies. For example, in the area of EdTech too, and for area of sales tech, and one of them is a mail management firm situated in the Europe and the European Union. And of course, despite the fact that I'm living in Ukraine, I'm working as a Ukrainian lawyer and holding the certificate of Ukrainian University as a lawyer. I'm still working in privacy area since 2018. And it's a very, very fascinating way to pursue, I have to admit. And of course, this dozen of videos that one of them you are watching right now is just another one in the series that we are recording here in Legal IT Group as our regular webinars. We have these webinars once in a while when we are talking about GDPRs, enforcement, news, and everything like that. And of course, we decided to try in English too, because it's always nice to see new faces and always nice to meet new faces too, just like we meet our partners abroad. Hello, Alexei. Hope Kharkiv is holding. I heard it's a very dangerous situation here today, just as any other day. So please keep safe. Okay. Okay. We will start with the controversial thing, because every privacy lawyer that works with GDPR and works in a global area and global market is always very, very interested in how to make the data flows and make the data mapping as solid and as compliant as possible. And of course, given that most businesses are registered or working from the European Union and from the United States, they was interconnected to ignore the Schrems 2 case and Schrems 2 judgment. And of course, every one of us want to know what is happening with the US Privacy Shield 3.0. So, as far as we know, since March, nothing really changes. We have this declaration from the President of United States and the President of European Commission that there will be some agreement, maybe some treaty on legalizing this as a privacy data flows from European Union to US. But still, we don't have any concrete proposal. We don't have any text that we can work on and can prepare our organizations to. So if you are worried that you could miss something, you didn't miss anything. So no worries. We just have this press release published by the White House that we will be seeing new redress mechanisms. It includes an independent data protection review court. And it's really interesting for me to see, of course, how this will work, and we will integrate it in our judicial systems too. Of course, the United States promises to review its signals intelligence practices, more meaning its surveillance, of course, policies that are working under the umbrella of national security, as far as you know. And of course, the White House expresses the intent to obtain adequacy decision. So we are not talking about the treaty; we're talking about the free flow between two, geopolitical powers. We'll say it this way. So of course, we are thrilled. I am actually very, very fascinated by the idea of seeing how they can do it in a legal way to respect the privacy rules and to align to very different frameworks and different approaches to privacy and data protection that is well presented by the European Union and the United States. So especially I'm really looking forward for this at least proposal to see and understand how it will work. As to the other news, we have decision of Swiss National Accident Insurance National Data Protection Authority working and adopted on the federal level. It's important because we understand that Switzerland is a few countries aligned in one. And they have this decision, whereas actually a good practice to teach a lesson to everyone who is going to build the solid proof compliance program. So we have the SUA, the Swiss National Accident Insurance Fund. It's like a public thing. It's not a private company like the most companies that are struggling with the GDPR are. They are a big issue, of course. They conducted a risk assessment because they wanted to use a cloud solution instead of in-house solution to store data. And they did everything they could actually under the GDPR. They conducted the risk assessment and then submitted it for review to the Data Protection Authority, of course. And authority asked them to reconsider its decision. So we have a very clear signal here that, of course, we can't work without the most of US provided services, but still we have to do something with privacy and especially with security, because since 2019, in Trump's 2 case, we can do nothing to to circumvent this this cornerstone idea that all data flows has to be secured. So if you have any idea how to outsource your solutions, how to outsource some of your storage or maybe some processing operations to abroad, you can see that a risk assessment is a must, but it's not panacea to help you to avoid any violation, given that there are some issues or maybe some concerns that your regulator has in relation to the United States. Yes, thank you very much for writing to me in the chat. It's always so nice to meet our colleagues and exchange news, of course, and see what do you think about this news, because it helps to stay aboard and to understand what is going on in the privacy world. Because we have so many newspapers, we have so many newsletters that are telling us the news about the recent fines and everything and all. But it's always so precious to have a discussion with your colleague to understand and exchange views and experience too. So please write first in the chat. I'm looking forward to read everything that you write there. Okay, so yep. Andrei says the data protection review court is actually just the data protection office disguised at the court. Yes, but still, we had this privacy shield idea that there can be an arbitration, some kind of third-party court, or we will say that arbitration thing, like alternative to the court. It seems it didn't go well, but we will see what they devise this time, because of course without this core issue with surveillance and without unjustified surveillance, of course, I highly doubt they can go far without really changing something in their national policy, I'm afraid. So, well, I side with you in this case, I believe. Okay, so we had two biggest things that were discussed this last weeks, and of course we have some fines to look on and well learn. We have the European Data Protection Board, and we have the advertising market that is very very important for us all. And starting with the European Data Protection Board, in May, European Data Protection adopted draft guidelines on calculation of administrative fines under the GDPR. Well, nothing really changes again because amount of the fine remains in discretion of the supervisory authority, subject to the calculation rules laid out in the GDPR, especially to the thresholds. Remember, 2%, 4% of fines, or some 20 or 10 millions of euros, depending on the annual turnover. You remember this, that there are some limits for the fines imposed by the GDPR itself, but there is a methodology introduced that I hope will help to align all the policies in different countries, so the DPO, regular DPO, can at least have some benchmark to look at and understand how their work will be assessed by the supervisory authorities. So this methodology includes 5 steps, starting with applicability of Article 83.3. It's the negligence. Then starting with finding the starting point, whether negligence has taken place at all or not. There are at least two cases. Then the supervisory authority has to understand whether there are any aggravating or mitigating circumstances too, to assess the legal maximums for the infringement, whether it's one or multiple infringements, of course. And finally, it has to justify the effectiveness, proportionality, and dissuasiveness of the fine. Simply said, whether this fine is enough to prevent any other violations of the GDPR, or maybe something else should suffice, for example, reprimand to stop the process in operation, or maybe saying something like that. We will talk about reprimands a bit later, but still, we remember that fines are not the only solution, that any violation can be corrected with different methods that the only supervisory authority sees fit. And of course, we remember that even if there is an administrative fine, we can refer to the court and ask them to review the decision. Maybe we are not that negligent after all. And of course, even despite the fact that there is a methodology introduced, human assessment of the facts must be conducted. It's not like a strict rule, strict procedure that will be automated in the future. There is always a human assessor who is sitting behind the desk and deciding whether it's enough or not. Of course, we remember about that. And it's a draft guideline again. If you have any experience, or if you have any considerations that you think are very fit to share them with the European Data Protection Board, you can go to their website and leave the feedback. Usually they collect some feedbacks over time and they adjust their text to considering the feedback. So maybe you have a very high risk that they will hear you after all. So why not? And of course, anyone who is working with marketing, everyone who is working with advertising knows about the IAB consent framework case that was taking place in the start of this year, in the beginning of this year. And we see that this fight for advertising market, of making it more compliant, making it more transparent for every one of us, is going on because in the beginning of this month, IAB Tech Lab, you remember that it's an entity that works on standardization of the marketing practices around different companies, has introduced a global privacy platform it's not the first, it's not the first global framework that is proposed. Google has one as well called Privacy Sandbox. But still, it's interesting how to see how people try to standardize and help to other countries and other entities and other actors and, of course, data subjects to understand how it works, understand what choices they have in relation to their the data privacy too. So, what is this global privacy platform? IAB Lab calls them a single protocol designed to streamline transmitting privacy, consent, and consumer choice signals, and it covers both the GDPR and CCPA in the US. If you were working with a TCF platform before, you know that they have some signals, some strings called strings that help to understand whether this ad is GDPR compliant or not. At least it was designed to help to understand. And in this area, I believe that it's the logical consequence or the logical development of the previous point of view on this issue, because before we had a big struggle with consent. We had a big struggle with different publishers, meaning different websites that were operating. You could not be 100% sure that all the consents were actually collected and that they can be withdrawn as easy as they were given, and there were always legitimate interest struggle, of course, because some IAB Law, for example, in its TCF platform offered two choices between the consent and between the legitimate interest to collect cookie files. And we will see that Belgium before opposed the IAB Europe's TCF platform in terms of consent opt-out and treating the TC string as a personal data, because, of course, you could never be sure that every website where your advertisement is shown is in fact compliant, that all the consents were in fact collected lawfully and they were not forced, maybe some other things. But, this I believe that this platform is designed to help you navigate the internet without being nauseated with cookie banners everywhere. So we will see where it goes. And still, it's just a launch. So we will see where it goes. We will see what Max Schrems will say next about that, I believe. So the bombshell: Data Governance Act adopted. We understand that GDPR is not the single, it's legislation that is to operate forever and ever, but it will be a part, maybe an important part, but still a part of the general privacy legislative framework. And it will cover not only the personal data, but non-personal data, open data, public data, and all of other kinds of data and privacy-related issues that arise when you have a global and mostly digitized market and economy. So we have this Data Governance Act adopted. It will enter into effect soon, tomorrow, and we will apply in full from the next September. The main idea, you can read the text accessing the link that I left you below in the footer of the slide. But just to start, there are a few things that I wanted to tell you how to understand what this act is about if you have never heard about it. So the Data Governance Act creates a mechanism for using certain categories of protected public sector data, which is conditional, of course, on the respect of the rights of others. So GDPR never goes anywhere. So prior to sending this data, you have to understand that it's secured, that it's pseudonymized maybe, that it's accessible only to some people, and so on and so on. GDPR still remains in force. But still, so GDPR is not derogated, but still, prior to making personal data, public sector data, meaning that Data Governance Act covers the public sector data. It's important. Prior to making this data accessible to everyone, the sharing entity must anonymize or make this data accessible only in a secured environment. So the data is still controlled. You understand who has access to it and who has the use of it. And of course, the data, The data exchange helps to start a business intermediation service, for example. Well, by obtaining the permission to use somebody's data via their personal data sharing intermediary. So, well, we live and we see the data wallet. Yeah, interesting how it works, but still we see this data wallet. Why not? So, and the most interesting thing, this act introduces data altruism. Meaning, if you have some, for example, health-related data about the rare disease that you could share with other people that could foster the development of treatment, so why not to share? Why be stopped with, for example, with ineffective treatment facility you are in or ineffective research lab you are working with? You can share it with all the labs, for example, and maybe some young, or maybe not young, not very young, scientists can take it, can run tests, and can understand how to treat the disease that you have, or maybe your child have, or maybe your loved one have. So creation of data repositories, it seems very, very logic, as well as data wallets in this regard too. And well, we have one more formal expert group, the European Data Innovation Board, that we will work on data wallets, we work on guidelines, we work on recommendation, and so on and so on. We have European Data Protection Board, we will have the European Data Innovation Board. So the more the merrier, I believe. So well, we will see where it goes. As of me, I'm really thrilled because it's a new age, it's in world, in making this all data legal and make it regulated source of income. So why not? As we are all privacy professionals, I believe we are either working as privacy professional now or we are thinking about transmitting to being one. I consider including in this little presentation a few tools that I'm personally going to use, for example, in the next task that will require them. So we will start with the Bavarian Data Protection Authority, who published a guide on risk analysis and data protection impact assessment. It's only addressed to Bavarian public bodies. It's important to remember. But still, we have the guideline presented to us by the Working Party 29, you remember. We have and endorsed by the European Data Protection Board later. We have we have our national supervisory authorities who too have their own guidelines as to the data protection impact assessment. Still, we have one more, and especially if you're working in the public sector or you're working with the government sector, for example, such as SUVA, you can rely on them to understand how are you expected to treat the risk, to understand what the risk is, and to mitigate it. So, and even if you are working in a private organization and you are only tasked with a DPIA on your local private organizational matter, you can still use it as a benchmark. Why not? The more information, the better you can understand how to deal with the TOMs, for example, meaning technical and organizational measures of protecting personal data. Still, it's a recent piece of guidelines that we have, and with security measures, it's never hurts to have the recent guideline that can help us to choose and use only the security measures that are most relevant given this period of time. I include all the links, so you can go after yourself, and you can email me, and I will send you this, for example, all these links included in the email, so no worries. You don't have to, type it yourself in the command line. Next, the Fintech Print adopted a draft guideline, again a draft guideline, certification as a tool for transfers. As of now, we have only a press release, but not the text, but we are looking for one. And of course, Luxembourg, it's interesting that Luxembourg Supervisory Authority has adopted a certification mechanism on a national and international level under the GDPR. So for the first case, when we have a certification mechanism that still certificates not the whole organization, but specific processing activities. So remember about that, we use them too. So we can, if you are working in Luxembourg, and if your client has an entity in Luxembourg, you can look at it, and maybe it will help you with your privacy scheme. It can help you with your certification scheme, and maybe it will help you in general, even making your clients believe that you care deeply about their privacy after all, because you are certified. Why not, if you can't do that? And last but not least, French Data Protection Authority publishes its guideline regarding the use of Google Analytics, and still no. French decides that Google Analytics cannot be used because it violates the Schrems II decision. Of course, it violates rules on international data transfers. Just a quick answer to the questions that we all have. Even despite the fact that Google proposed a few security measures that can help actually transmit their data safely, the only thing that they named as mechanisms that can be, after all, applied is a proxy server. Well, if it's suitable for you, you can consider it. At least you will know where to refer next time when you are asked what you can do with Google Analytics to make it GDPR compliant. Next. Thank you, GDPR Hub, for all the information about the fines. So we have a few interesting cases that I wanted to outline because they're very popular in our day-to-day privacy works and privacy tasks. We will start with cookies, because cookies are one of the things that is not clearly GDPR dependent, but still very understood as a part of the GDPR for some reason. The Belgian DPA fined the media group for not obtaining prior consent to place cookies, and it's like a landmark fine to outline everything that can go wrong because the placement of unnecessary cookies prior to consent of the data subject was present, a placement of statistical cookies without consent was present, pre-ticked boxes, placement of disclaimer for third-party cookies, of course, false and inadequate information in their privacy policy as well, because you can see that many privacy policies are written very hastily or very vague, or maybe some even automated by using one of accessible online tools to generate one and not think about it twice. Still, unjustified detention periods too, and revoking consent was impossible because it led to placement of more cookies. So as you can see, everything that could go wrong went wrong. And when next time you're asked about the cookies, you can use at least this case and find to explain how it should not be done, because it can lead to a hefty fine too. Another traditional thing that every one of us are concerned with is security. And we have the Uber fine, because Uber failed to notify the supervisory authority of a data breach. And of course, inadequate privacy notice again on the website. And there is a reason. It's a recent trend to treat geolocation data without consent, and we have an interesting issue there, because a few countries like Austria, they are saying that geolocation data cannot be in some regard treated as personal data. It's non-personal data, and it can be it doesn't have to comply with the GDPR. What do you think about this? Is it personal data or not? We will see in the future, maybe in the future issue of this, webinar Gazette, maybe. We will see. And the next case related to the security is outsourcing again. We have the platform that helps to realize the whistleblowing scheme. You remember that there is a whistleblowing directive adopted to, and it must be transposed in the national laws very, very soon. So every European country has to have some kind of whistleblower scheme to signal that there are privacy in compliance in an organization too. So an organization used a third-party platform for collecting whistleblower reports, and it done so without implementing necessary technical organizational measures. Again, security is important, even despite the fact that it's only referred in one article, the GDPR Article 32. Technical organizational measures are everything, and you have, even despite the fact that you may be a legal professional, you have to work closely with your information security team to understand and have the list of the terms near your hand every time you are dealing with GDPR and outsourcing too. We'll go next to the data transfer because it's very closely linked to security. And we can see that there is a new, very, very, let's say, dangerous place, third country, where you can transfer your data for processing. Earlier, we had the media coverage of the transfers of data to the United States and China, and now I predict we will have a lot of articles about data transfers to Russia. And as I remember from the latest press release from the European Data Protection Board, they were asking for a mandate to issue a guideline about data transfer to Russia. So I expect one maybe in this year, maybe in the start of next year. So we will see. And we have this case of a hospital network in Belgium who wanted to find a contractor to process patient data of hospital for statistical purposes, to understand the trends and maybe do some service research and so on and so on. They offered the public procurement scheme, and the company 3M, a US company, won the public procurement. They wanted to, give the parts of this analysis to their Russian company, for example, their Russian partner company Smart Analytics that is based in Russia. And another contestant that was wishing to win this procurement scheme noticed that, made a research, for example, media research, where the 3M company was named as transferring data to the US and Russia without appropriate safeguards, and reported this to the Supervisory Authority of Belgium. And in the end, the supervisory authority suspended the contract with 3M company of Vivalia, just because it was found that Vivalia did not carry out the necessary procedures to make this data transfer legal in terms of data transfer to the third countries. Well, we have this situation very clear. Nobody is actually insured against this, but still, as a privacy professional, we have to understand that even procurement office, even this, something as simple as statistics has to be analyzed and has to be compliant with the GDPR. And this maybe is the thing that can be your next topic for company-wide training, for example, just to raise awareness that we have all the European Union, we have the third countries, and we have to carry out necessary procedures that we ask them to carry out, because it's important for the GDPR compliance and can result in a fine or even suspension of a contract with our beloved contractor, for example. And another ticking bomb that we have is always employees and contractors, because despite the fact that we believe them, that we entrust them, the personal data that we are entrusted with, we still have to respect the GDPR, and not only in regard to their own personal data, but in regard to the processes, again, because the GDPR is not about personal data only, about processes. It's about the organizational measures, about technical measures, about the privacy culture inside the company. So everyone knows what the GDPR is, what does it cover, how can it be applied in their routine job, how can they apply it to make the service better, and so on and so on. And we have two recent cases when the controller did not provide data subject with access to their email, for example, that we were using when they were back to time when we were close employees or contractors themselves. For example, the first case refers to the non-provision of data subject with sufficient information on their policies regarding work emails, and denied access to the work email without explanation. And it was, actually a scandal, because sometimes you will work with a person, and it can be can allegedly breach the GDPR and the policy. You cannot just simply deny them access to their email. They have, because we remember that the European Court of Human Rights, again, had a few decisions about the emails and about the privacy during the work hours. That every employee, every contractor, that even despite the fact that he or she uses a corporate email, still have their own privacy, still have their own rights with regard to the email that they receive, even in the capacity of representative of the company. And still, you cannot simply deny all of a sudden the access to the emails and do not grant them the possibility to look through the emails and maybe delete or download information that's deeply personal, but not really the corporate one. So in the first case, it was a decision like that. And in the second case, we had an additional layer of violation because all the emails that were going to the others blocked email address were automatically forwarded to the general manager instead. So even if it was something deeply personal, it could be automatically transferred to your former employer, and you can understand why it was a violation of privacy because you must have an opportunity to come back to explain to the clients that you're working with that I'm no longer an employee of this company. This email won't be operating for after I leave because we have other people working on your task or your project, for example. You have to introduce them. You have to hand things over to your manager or maybe to your successor, and you have to protect your own privacy to delete everything that's deeply personal. For example, even if you have some kind of informal conversation with your client, for example, or maybe representative of your client. So, well, employees and contractors has to have their own policies. They cannot be simply denied access to the email at any time, and there must be the procedure and the mechanics for them to access their former email address and, well, protect their privacy, to download everything that's deeply personal for them. So if you have any questions, if you have any updates, or if you think that I missed something really, really important in this month when covering the recent events, please write in the chat. If you want to express your opinion on something too, or if you want to exchange maybe an important piece of news that you want to hear next time, or you want to discuss next time, and maybe if you have an intent to talk with us on the next webinar, feel free to write us. Feel free to write in the chat. Feel free to contact us in the LinkedIn and maybe or using our email as in the previous slide. And let us know. We are always open for cooperation. We are always open to talk and discuss things that are important for in the area of privacy because, well, privacy is very, very fascinating. And it's very important for us too, because we remember that the compliance costs are only rising, and we have to be the top-notch professionals to spare the effort, to spare funds, to spare the risk for our employees and working our clients when we are working with data subjects, of course, too, and to prevent any abuse of personal data, of any privacy things, of any expectation of privacy that the company can, in fact, use against our customers and our clients as well. Thank you very much for being with me today. I hope that you liked the webinar. I hope that you heard some interesting things for you to use in your next working day, for example, if it's the end of the day where you live. And of course, I hope that we will stay in contact. We will meet regularly today, for example, as today, to discuss recent decisions, to discuss what is going on, and discuss and exchange the news and experience, just to create this network of privacy professionals that, well, align and work and align well. Thank you very much, and I'm looking forward to see you again. Bye.